The question of, or the matter of plea bargain has always been in and out of the news lately, but it was more so, I think it was 2 days ago, where the CJN was in that for the Human Rights Commission was also there, NBA had some presence, lawyers were also there, and they're all talking about this matter, to be or not. Well, there was a report about that scenario. We'll take it now.
The plea bargain system of conviction has been a subject of controversy in the recent past. Addressing a gathering on plea bargain and other emerging trends in the criminal justice administration in Nigeria, the chairman of the National Human Rights Commission, Professor Chidi Odinkalu, disagreed with the position of the Chief Justice that the concept of plea bargain is of dubious origin. Professor Odinkalu argued that, on the contrary, plea bargain is a critical tool in quick dispensation of justice.
We will come to know that the concept of plea bargain is not only obnoxious, as I once described it, but you will see that it had never been part of the history of our legal system, at least not until it was surreptitiously smuggled into our statutory laws with the creation of the Economic and Financial Crimes Commission, EFCC.
The legal bases are very clear. When you look at Section 181 of the Criminal Procedure Act, which has been there for a long time, well before the EFCC Act, it's a very firm legal basis for a plea bargain. When more charges than one are made against a person and a conviction has been had on one or more of them, the prosecutor may, with the consent of the court, withdraw the remaining charge or charges, or the court, of its own motion, may stay the trial of such charge or charges.
Professor Odinkalu, however, agrees with the Chief Justice that the application of the policy needs to be reviewed.
That the body of Attorneys General should get together and adopt and publish a set of guidelines on the administration and deployment of the plea bargain. That's number one. At the judicial level, there is also, because as I say, there can be no plea bargain if it is not certified by a judge or magistrate, as the case may be. So, why don't we have the National Judicial Council to doing what? Debating the role of the plea bargain in the criminal justice system and producing a set of guidelines to govern the administration and certification of the plea bargain in criminal justice processes.
The debate is on, but participants at this event agreed that the policy should not be the privilege of highly placed criminals, but should be available to all citizens of the country in the criminal justice system of Nigeria.
Well, there you have it, taking a look at the plea bargain matter. Mr. Wahab Shittu joins us now. He is a lecturer in law and a legal practitioner. Thank you for coming on this morning.
It's my pleasure to be here.
Well, it's amazing. Some of the response we've got it from a whole lot of people, including laymen, think that plea bargain just seems to be an escape route for those who, they use the word criminals, an easy, providing a soft landing, perhaps maybe latching onto what the CJN seems to be advocating at the moment. But give us your sense of what you think is going on now with this plea bargain discourse.
Well, I think the first thing for us to appreciate is that in looking at the concept of plea bargain, we have to look at it holistically against the background of our own peculiar circumstances. We all know the problems we have with the normal system of administration of justice. The problem of delays in the administration of justice, the problem of undue technicalities, sometimes problem of corruption. You also have problems of, the integrity of the process, as well as conjunction of cases in court. And against this background, and given the outcry of members of the public that to see that corruption is reduced to the barest minimum, how do we fast track the process? How do we reduce congestion of court cases? How do we ensure that cases are speedily tried, devoid of some of these delays that I speak about is occasioned by the rules of court itself. Some of them is because necessarily, for instance, when an accused is arraigned before a court of law, is entitled to legal representation. Counsel retained by accused persons are also entitled to deploy all manner of tricks in order to frustrate the trial process. And this is the accepted norm all over the world. That is why we have to understand the emergence of plea bargaining in this context. If, for instance, how do you do justice to the society, to the victims of criminal offenses, and even to the cause of justice generally? That is why the issue of the idea of plea bargaining has arisen, and it's not a peculiarity of Nigeria alone. It exists under we have the US model, we have the UK model, we have the Canadian model, we have the Indian model, we have plea bargaining in Germany, we have some form of plea bargaining in Italy, and all of these people. But the most important thing is that there are ground rules, so that to forestall abuse.
But the CGN says that's why he doesn't seem to subscribe to, because it's been abused. In fact, some headline says EFCC corrupts plea bargain system.
Well, I think the emphasis is how do we ensure that plea bargaining is not abused. I listened to Professor Odin Kaludaya, and I think I'm in total agreement with the views he expressed. The bodies of attorney general should come together and work out the framework. So other than that, the NJC should set out the ground rule, because the plea bargaining itself has its own advantages. For instance, it reduces the length of the trial process. 2, and then accused persons who would normally have gotten away with acquittal are convicted. I mean, you understand me? And then, secondly, the society itself benefits in some way, because those who who normally have run away from some of these, highly grievous offenses are convicted. Yeah. So you see, these are some of the advantages. But we need to ensure that the procedure is not abused.
So we mean that as we've been practicing it, because apparently we have been practicing plea bargaining, especially in cases of corruption. There have been no set ground rules. We've just been practicing it at our own discretion. Well,
there is some kind of some degree of provisions in the EFCC Act permitting this, but effectively one can say that we don't have an effective legal framework in place to set out the parameters, the ground rules for the application of the plea bargaining, and that is the area of concern, where you must have a legal framework in place, and plea bargaining is a tripartite is an agreement. Some people call it plea deal or plea agreement. Essentially, it is an agreement in a criminal trial between the prosecutor and the defendant, suggesting that the defendant is ready to plead guilty to some lesser charge, or to the original charge, or to some charges, so some counts in the charges, in return for certain concessions, or in return for a lenient sentence. That is the idea. Yeah. That is the thrust of plea bargain. So now it is anticipated that before this takes place, all parties must be taken into confidence, and the accused person who now decides to plead guilty, rather than go through the lengthy trial process, must be assured at the end of the day that he will enjoy some measure of concessions, either in terms of a lenient sentence or some other concessions. Otherwise, he will not go into it. Secondly, the judge too must be sensitized, because there is no plea bargain that can take place effectively without the sanction of the court.
So the judge is the third party,
yes,
in the tripartite.
The concern that has been raised in the way plea bargaining has been applied in the country is because sometimes you find out that the judge just comes out at the end of the day with a very lenient or ridiculous sentence, and people begin to wonder, is this really worth it? That is why there must be ground rules. Judges need to be sensitized. All parties involved in plea bargaining needs to be sensitized. But definitely, and that is one fact we must not overlook, we need some form of plea bargaining in order to move our criminal justice system forward, given the challenges that we face.
What ground rules should there be to ensure that judges don't come up with, as you said, flimsy sentences?
Well, there should be legislation. There should be a legislation on plea bargaining, setting out the rules. In all these other jurisdictions that I've mentioned, in US, in the UK, in France, in Germany, in India, in Poland, and these other Commonwealth, common law countries, there's a legal framework, and then this legal framework sets out the parameters, including the limitations. For instance, in the US, nearly 90% of the cases, criminal cases, are resolved through plea bargaining rather than through the jury trial process. And this has ensured that cases are speedily resolved. And in the UK example, for example, where the former governor Boris is standing trial, under the UK system, they also recognize what? The idea of plea bargaining. But the prosecutor and the defendant must agree. The accused person must agree to plead to some of the charges in return for the withdrawal of the remainder. That's one.
Who persuades the defendant to agree? Is it his counsel or the person?
And that is why that's also very important. Free bargaining must flow from the free will of the accused person. In other words, the accused person must not be under any form of threat.
How is that?
Or any form of coercion. He must look where his own circumstances. He's the one on trial. He's the one who knows whether he's guilty or not. He weighs the implications. For instance, plea bargaining ensures, for instance, you have to look at the incentives to the accused person. One, he can easily get out of jail, for instance, depending on the arraignment. Ordinarily, he may be entitled to some kind of punishment, and he has spent some length of time in detention. He wants to get out quickly and enjoy his freedom. Okay, against this background, he then decides to, own up. And then the period he has spent in detention is reckoned by the judge in computing the sentences. So you see, it's safe for the accused person. It allows him to get out of jail quickly. Two, he saves his money, because money expended in the course of plea bargaining is far, far less than he would normally have expended if the trial has gone the whole length.
But they also say that, predicating their arguments on part of this submission, that in this climb, perhaps, they don't see how plea bargaining will benefit the justice system or the society at large, because the monies that is alleged to have been looted by some of these persons who are on trial is far much more than they will ever give up with this plea bargaining. Because, if you give up a certain percentage or portion, you go from rags to riches, and then they can't reconcile it.
Well, that's a point, but I think you also have to appreciate the fact that in a criminal trial process, sometimes it is difficult to be able to predict the outcome. And you cannot also determine the length of the trial process. Yes, the Nigerians are unanimous that, the issue of corruption must be tackled. But there's no way you can tackle corruption without adherence to the rule of law. And adherence to the rule of law means that you must subject those who are accused of corruption to the trial process. And the trial process has its own rules. There's no way, for instance, you cannot prevent an accused person from bringing a preliminary objection, for instance, challenging the charges, which can be argued as far as the Supreme Court.
Whoa.
And this could take him a number of years to resolve, without even getting into the main. So if you have an arraignment that will say, the man agrees, I will plead guilty. Look at the Cecilia Ibu case, for instance. Look at the amount of money that was recovered
That was plea bargain.
Yeah, plea bargain. About 192 billion that was recovered. I mean, that was returned to the coffers of the state by virtue of that arrangement. And again, you also look at the stigma of conviction. People overlook that. In some jurisdictions, like I think Canada, for instance, let me confirm. If you plea bargain under that jurisdiction, you are convicted, but you are never sentenced. But you lose some benefits in terms of participation in elections, in terms of holding public offices, and you can also be dismissed from your employment if you're a public official. So you see, these are some of this, but it's also convicted. He or she becomes what? An ex-convict. And that is a stigma that hangs on your neck perpetually. So I think when we are talking of this, we all know that we have a major problem in our administration of justice in this country. The problem of undue delays. And this arises both in civil and criminal proceedings. Now, some cases might take as far as 5, 6, 7, 8, 10 years. When vital witnesses, some of them will have died. And then when, some of the memory too, about the facts of the case will have diminished. And so you should look at it from, I think we should appreciate the fact that, okay, do we actually want speedy dispensation of justice? These are mechanisms that have been successfully employed in other jurisdictions around the world. Yeah. In USA, in UK, in Canada, in Germany, in Poland, in India. This plea bargain is a feature in France. So if we claim that we want our democracies to mature, then we should be able to, employ some of the mechanisms we have employed in other climes, subject to the peculiarities of our circumstances. Right, but I'm also of the view that in employing the technique, all the stakeholders involved must be sensitized. Okay. Particularly, the prosecutor must act. I think 3 or 4, specific interest groups need to be effectively sensitized. For instance, the the defendant must act on the basis of his free will, devoid of coercion, violence, or threats. It must be something that flows from his free will. The prosecutor too must act in the larger public interest. Larger public interest is that you weigh, in other words, it imposes grave responsibility on the prosecutor to be able to look at what in the end will benefit the society, given the circumstances and peculiarities of each of these cases. 2, there must be an agreement that reflects the will of the two parties effectively, taking into cognizance some of the variables I've mentioned. Again, we must have a framework that will also ensure that the victims of the alleged, crime is carried along. In some jurisdictions around the world, the victims are consulted before a plea bargaining arrangement is finalized. Again, you also have to sensitize the court, to appreciate, because in most jurisdictions, you plea bargain in respect of the charge, but you cannot plea bargain in respect of the penalty to be imposed. Like in the UK jurisdiction, for example, you can agree between the prosecutor and the defendant, but you cannot plea bargain on the penalty to be imposed, because right now we know that the former governor of Delta State has pleaded guilty in the UK court. What is clear now is that no one can effectively determine the penalty that will be imposed. Because that is subject to the endorsement of the court.
You mentioned an instance of where plea bargaining seemed to have given results. I mean, the case of Cecilia Ibro. But what's of a case where it seems that justice just wasn't met? For instance, in the case of Lucky Igbenedion, where he seemed to have parted with only 1% of what he said to have taken, where $25,000 was the only thing that was returned to the coffers of the state government in return for about $25 million that he took.
With due respect, that is an instance where plea bargaining has been grossly abused. We have said so repeatedly here that the danger in adopting the plea bargaining framework without ground rules, without legislation, is the kind of, is that it may be open to abuse, and that is why you see a lot of people find what happened in former Governor, Igbinadio's case laughable.
So
that did not even reflect.
What does the prosecutor do in that particular instance?
Of course, you can appeal. That's part of the framework. For instance, under an effective framework regulating plea bargaining, the accused person can rescind from the agreement before the final pronouncement. If it doesn't agree, if it does not reflect exactly what was agreed, if he has reservations about the agreement, he could rescind from it. Again, like we also mentioned before, the judges must be what? Must be sensitized. They must appreciate the magnitude of the responsibility placed on them.
All right.
And except you have a legal framework, which is what most people are agitating for in the Nigerian context.
Okay,
it is open to abuse.
About free will.
Yes.
And considering the fact that basically what we're talking about here is about fighting corruption. The CJN was quoted in November last year saying that the plea bargain is fraudulent and it's not helping the fight against corruption. How many corrupt officials do you think would, of their own free will, agree to a plea bargain when they always believe that there's no evidence against them?
Well, but you have seen that in some situations, particularly in Nigeria, some have done so based on their free will. You have cited the case of the Cecilia Ibu. There's also the case of former Governor Lucky Igbinadio. The only problem we have identified is the potential of what? Abuse. And then again, what we are also saying is that, okay, we are just adopting this procedure without formal what? Legal framework. And that is something that we have to look at. Again, we also have to appreciate the fact that our administration of justice system, whether in civil or criminal proceedings, is bedeviled personally with a lot of challenges. These challenges include congestion of cases, unnecessary adjournment, sometimes corruption, and then some people have also queried the integrity of the process. Others have also alluded to undue delays that we experience in the administration of justice. So the choice is really that of ours to see how we can effectively introduce mechanism into our justice delivery system without, looking at the model that will suit our circumstances.
Right.
I have told you that we have several models that we can look at. The US model is there, the UK model, the France model, the Canadian example, the Italian example, and the German example. All these are jurisdictions that have some degree of plea bargaining, whether generally or some limited application. In some jurisdictions,
all right,
they are only confined to minor offenses. You understand me? But in all situations, the authority of the court, the prerogative of the court to determine the final outcome must always be respected.